All right, so I am not going to allow you to withdraw your plea. We're going to go forward with sentencing. Mr. Nix, you may proceed.
Thank you, Your Honor. Your Honor, in reviewing the PSI, obviously the court's seen some of the evidence. It's not good evidence, but the one thing that I think needs to go in Mr. McGee's favor, obviously, is that he did take responsibility. He did plead. Obviously, he's gotten some bad legal information in the jail since we were last here in court. But that shouldn't change the fact.
Right out of the gate, this is a huge setback for the defense. The judge has just denied the request to withdraw the guilty plea, which means there's no do-over here. Focus now shifts entirely to sentencing. And trust me, what happens next will show just how much the judge remembers from the evidence in this case.
The fact that Mr. McGee has had no criminal history other than some traffic citations and a few failures to appear on those traffic citations before this. He's never been in our system. He's never been on probation before. Never been sentenced to prison before because he has no criminal history. Mr. McGee did not live the same life that many of us have lived. One of the letters that I received from a close friend, they've known Devin since 2017, so approximately 6 years. Not only did they speak very highly about how Devin typically put himself before others, and he had a very rough childhood, his mother passed away in front of him at the age of 27. They had no father figure. They were tossed and moved around with their 3 aunts from 2007 to 2017. They both suffered physical, mental, and verbal abuse from 2 of their aunts. Mr. McGee also has a 3-year-old child. He's never really stood much of a chance. He's never had a positive male figure in his life.
The defense is making a classic mitigation argument here. Difficult upbringing, no prior criminal record, newfound faith, and family responsibilities. In many cases, those factors can absolutely influence a sentence. But here's the question. How much weight should personal hardship carry when the crime itself involved extreme violence? Let me know what you think in the comments.
It's not my words. Those are the words of close friends and family members that have kind of written it in half. They were completely shocked and said that this was out of character for him to partake in this crime. They believed that he was following his brother. They said that this is not who Devin is. Obviously, the court has just what it has in front of them, which is the evidence from that case. And if you just look at the evidence in that case, obviously it's going to give you pause because of the nature of and the violence that took place in the offense. Well, my client understands the law of parties and he knows that he's just as responsible for whatever his brother did that day. I will say that he was not the aggressor or the main aggressor in this situation. The crime that they committed was despicable and he would agree with that. He thought that he was going over there to...
Watch this moment carefully. Defendants are often given a chance to help themselves during allocution, the opportunity to address the court directly. But if a judge believes someone is minimizing their role or shifting blame, that opportunity can backfire instantly. And that's exactly where this conversation is headed.
Stolen property. He did not know that his brother was going to start shooting. And visiting with Mr. McGee, I believe he was also a little afraid and didn't know what to do in the situation once it started going further and beyond what he thought it was going to be. Further, Mr. McGee has told me that he has found religion. He has one of his write-ups has been because they did not warn the jailer when they were going to pray. So that was one of the write-ups they had. He also had a jumper malfunction with his buttons. But he says that his newfound religion is giving discipline and peace in his life. He has a son now. He apparently did not know about that. I believe he became aware of that while he was incarcerated. His child was 3 years old. And he would like to have some sort of a life with a son. I would suggest...
That statement changes everything. The judge isn't relying on assumptions or secondhand testimony. He's talking about video evidence he personally reviewed. In sentencing hearings, credibility is everything. Once a judge concludes that a defendant isn't accepting responsibility, requests for leniency become dramatically harder to win.
Suggest he get 10 years deferred adjudication probation, and if he messes up even one iota, He's got the full range to deal with. So I would suggest that he gets 10 years deferred probation, be put on intensive supervision, zero tolerance, and actually be given a chance, because based on his criminal history, this is not who he is. This is not, and I hope the court doesn't take into account the fact that he tried to withdraw his plea today. I think he got some bad information.
No, I'm not worried about
Yeah, he got some bad information in the jail. But he is eligible for probation. I would ask that he get probation, and I'd give Mr. McGee a chance to address the court and explain why he should.
I didn't know, like my lawyer said, I didn't know that my brother was going to go over. He told me.
Hang on a second, Devin. Just stop.
Prosecution senses momentum here and isn't holding back. Notice how the argument shifts away from technical legal points and toward the impact on the victims. That's often a powerful strategy during sentencing because the court isn't just weighing the defendant's future, it's also considering the lasting consequences for everyone affected.
All right. Y'all went over there with the gun. Hang on. I've watched the video. And you were the one who egged your brother on the entire time. I'm not even sure that your brother would have done what he did had you not been there. Just in his face, do it. I've seen it. Hang on. I've seen it. There's probably nothing you can say right now that's going to help anything, because all you're doing is trying to not take responsibility instead of taking responsibility. Ms. Malfino.
Thank you, Judge. You just took the words right out of my mouth.
Sorry.
We're having no criminal history.
This is the moment the entire hearing has been building toward. The judge has repeatedly referenced the video evidence, the defendant's conduct during the crime, and what he views as a lack of genuine accountability. After rejecting probation and every plea for leniency, the court is about to deliver a sentence that will change the course of this defendant's life for decades.
Criminal history himself from 0 to 100 in a matter of 2 hours. On behalf of the Jack's family, we appreciate the court taking time when we address Tevin's case to carefully consider all of that evidence. This is a unique situation where I don't even feel like I need to argue the PSIS, everything in front of you. I know you recall it. I know you remember it. I know you know the violence there, and he was responsible for those actions. He needs to be held responsible. I appreciate Mr. Nick's argument. I respect him immensely as a professional. He's just doing his job. The words probation are just absolutely ludicrous for this case. I think Jason said it best when he told you this is not a gift to Devin. This is a gift to them to let this be over, to stop the night.